Good morning, this is your Kelso Report for Wednesday, February 29th, and I'm your host, Clark Kelso. Today we have cases dealing with death penalty, contracts, criminal law, sentencing and procedure, and insurance law. We've got two cases on the death penalty coming out of the Ninth Circuit Court of Appeals. In the first case, on the eve of his execution, the petitioner in Moorman v. Schriro tried to file a second habeas petition, raising two claims. First, that his original appellate and habeas counsel were so ineffective that they had effectively abandoned him, and second, that he is now mentally retarded and therefore may not be executed. We're going to be seeing quite a few of these cases where counsel has allegedly abandoned his or her client because of the Supreme Court's recent decision in Maples v. Thomas this year, where two New York attorneys actually did abandon their client, and the Supreme Court granted the petitioner relief from a procedural default. But actually abandoning your client is not the same thing as allegedly not presenting the most effective arguments. And so the Ninth Circuit rejected this claim in today's case. On the mental retardation claim, the Arizona Supreme Court had already considered this claim and rejected it under the state law definition, which primarily references IQ scores at or before the time a person is 18, which is a common definition. The Ninth Circuit held that it was required to defer to this conclusion, and the court denied the petitioner's request for relief. In the second case, Towery v. Brewer, we see a real problem here in Arizona. Implementation of the death penalty has really become a circus that's not worthy of our system of judicial administration. In Arizona, two death warrants had issued for executions. The first case we talked about, and now this one. After those warrants issued, the state modified its execution protocol to employ a three-drug protocol. The inmates challenged the new protocol, but that challenge was rejected by the district court. Then, after the appeal had been filed, and only hours before oral argument before the Ninth Circuit, Arizona advised the court that it was not going to use the three-drug protocol after all, but would instead use a one-drug protocol. Why? Well, the state discovered at the last second that the originally planned drugs had expired in January 2012. Somehow, the state managed to have missed the fact that the drugs had expired for about 6 weeks. Notwithstanding this snafu, the Ninth Circuit demonstrated, I think, surprising patience and affirmed the district court's denial of a preliminary injunction in an effort to bar the executions. We'll see if that holds, if there's any call for an in-bank. Seems to me Arizona displayed an unusual degree of incompetence here in implementing the death penalty. Next, we have a series of cases from the California Court of Appeals. The first is in the area of contract law. There's some real property in Riverside, and it was listed for sale as follows, quote, $17 million cash or such other price and terms acceptable to sellers, close quote. A broker produced a buyer with $17 million in cash, but the seller then rejected that offer and countered at $19.5 million. The broker claimed he had earned his commission. The district court granted a demurrer to the defendant because the complaint failed to allege facts giving rise to the existence of an enforceable written contract for the payment of a real estate commission. And the Fourth District affirmed. The plaintiff had read the listing as being an offer to sell either one, for $17 million cash, or two, for a different price on terms acceptable to the seller. But both the trial court and appellate court held that was the wrong interpretation. The listing actually should be interpreted as saying $17 million and terms acceptable to sellers, or some other price and terms acceptable to sellers. Given this interpretation, the mere presentation of $17 million in cash did not create a contract, and the seller's counteroffer constituted a rejection of the $17 million in cash and a new offer that was not accepted. The property was not sold to that buyer, so the broker did not earn his commission. Next, a couple of cases in criminal law. First, the defendant in People versus Liu was convicted under Penal Code Section 289 of sexual penetration by a foreign object of an unconscious person, oral copulation of an unconscious person, and sexual battery. The inappropriate touching occurred during a massage session, and the victim, who was awake, was immediately aware of the touching and oral copulation, and according to her testimony, immediately protested and then left the store. The defendant argued that there was insufficient evidence to support the charges of sexual penetration or oral copulation of an unconscious person. But the trial court held that the evidence supported the conviction because the victim was not aware of what had occurred until it had occurred. Let me say that again. The victim was not aware of what had occurred until it had occurred. Well, the 5th District rejected this rather, I think, silly reasoning. The victim's testimony was that she was awake and instantly aware of the sexual battery. Section 289 does not require prescience or advanced knowledge of an impending touching. Unconsciousness simply means the victim, quote, was not aware, perceiving, or cognizant that the act occurred, close quote. But by the victim's own testimony, she was aware, she did perceive, and she was cognizant. So the appellate court reversed the conviction under Section 289, leaving intact the conviction for sexual battery. Next, the defendant in People versus Rouse challenged his conviction on multiple charges of sexual abuse of a number of children. Claiming there was insufficient evidence, the trial court erred in permitting all charges to be tried before one jury. The instructions on intent and propensity were erroneous. Expert testimony about child sexual abuse accommodation syndrome was admitted, and the trial court failed to instruct on lesser included offenses. The short of it was the 6th District rejected all of these arguments and affirmed the conviction. We're not going to go into that one in any greater detail. Next, criminal sentencing. Section 1202.05 of the Penal Code provides that whenever a defendant is sentenced to prison for certain qualifying crimes against a minor, the sentencing court must prohibit prison visitation between the defendant and the victim where the victim is, quote, a child under the age of 18, close quote. In People v. Scott, the trial court sentenced the defendant to prison for sexually abusing 2 minor females and applied Section 1202.05 to prohibit visitation with both victims. Although one of the victims was his daughter, who was over the age of 18 at the time of sentencing. The 6th District held that Section 1202.05 applied only when the victim was under the age of 18 at the time of sentencing. And so the court vacated that portion of the sentencing court's judgment. As the court explained, the danger addressed by Section 1202.05 is that a child's caregivers operating in a state of ignorance or denial may subject their child to injurious encounters with their imprisoned abusers. But this danger disappears when the victim is no longer subject to the control of his or her parents or guardians. So, Section 1202.05 should be interpreted as applying only when the child victim is under the age of 18 at the time of sentencing. Next, criminal procedure. The rule in California is clear that an appellate court does not have jurisdiction to entertain an appeal that a guilty plea was involuntary unless the trial court grants a certificate of probable cause. No such certificate was granted in People v. Briseno. However, in granting relief to his federal habeas petition, the Ninth Circuit directed the federal district court to enter an order requiring the release of the petitioner unless his ineffective assistance of counsel claims that led to his guilty plea were reviewed on the merits by a California appellate court. Now, in response to that order, the 6th District had granted a motion to recall its remititure from 10 years ago, thereby reinstating defendant's appeal and maintaining him in custody. But with its opinion yesterday, the 6th District reiterated what it had held 10 years ago. In other words, there still is no appellate jurisdiction absent a certificate of probable cause, which never had been granted. As the appellate court explained in pointed criticism of the Ninth Circuit, quote, "No writ of habeas corpus can supersede this basic procedural impediment to appellate review. And to the extent that the Ninth Circuit Court of Appeals believed or assumed otherwise, it was mistaken," close quote. So now my guess is the case bounces back to the federal court, and we will see what the district court decides to do. My guess is that we could be headed to the United States Supreme Court if the Ninth Circuit isn't careful in how it handles this case. It's got a little bit ahead of itself in trying to direct the appellate court, the state appellate court, how to handle its own jurisdiction. Next, we turn to insurance law. In a matter of first impression under California insurance law, the 4th District held in Pacific Rim Mechanical versus Aon Risk Insurance Services West that an insurance broker who procured a policy of insurance for a developer does not owe a duty to a subcontractor who was later added as an insured under the policy, does not have a duty to inform that subcontractor of the insurance company's subsequent insolvency. As the court explained, an insurance broker has only a limited duty to his or her client, and that is only to use reasonable care, diligence, and judgment in procuring the insurance requested by an insured. The duty does not extend to subsequently notifying the insured about changes in the economic fortunes of the insurance company. As the court noted, if an insurance broker's duty is to be expanded in this way, that expansion should come from the legislature and not from the courts. And that's it for today's Kelso Report. Have a great day in the law.